दोस्तों, अगर डिक्टेशंस पसंद आएँ तो लाइक, शेयर और सब्सक्राइब ज़रूर कर दीजिएगा। अगर आप इस चैनल पे नए हैं तो लाल रंग का सब्सक्राइब बटन है, बेल के साथ दबा दीजिएगा ताकि आपको आने वाली डिक्टेशंस टाइम टू टाइम समय पे मिल सकें। थैंक यू। Heard Shri Shrish Srivastava, Learned Counsel for the Appellants, and Shri Arvind Kumar, Learned Counsel for Respondent, New India Assurance Company Limited, full stop, para. This FAFO has been filed by the claimants being aggrieved by the award dated 14/8/2020 passed by the Commissioner under the Employees Compensation Act 1923 at Kanpur only, on the ground that the income of the deceased has been construed at rupees 8,000 in bracket 8,000 rupees bracket out per month, whereas he was drawing a salary to the tune of rupees 12,000 in bracket 12,000 rupees, but learned tribunal has not even taken the income, that is minimum wages, as applicable on the date of the accident for a skilled laborer, that is at the rate rupees 9,873.08 in bracket 9,873 rupees and 8 paise bracket out per month, full stop. However, taking into consideration the cap provided under the Employees Compensation Act on the maximum income to be computed for the purposes of compensation at rupees 8,000 in bracket 8,000 rupees bracket out per month, compensation has been calculated taking income at rupees 8,000 in bracket 8,000 rupees per month and not even at the rate of minimum wages prescribed by the state government for a skilled laborer, full stop, para. Learned Counsel for the appellant, though vehemently submits that wages should have been computed at least at the minimum wages prescribed by the state authorities, but is not in a position to dispute the fact that an amendment was effected in section 4 in bracket 1B of the Employees Compensation Act 1923, whereby it is provided that the central government may, by notification in the official gazette, specify for the purposes of subsection in bracket 1 such monthly wages in relation to an employee as it may consider necessary, full stop, para. The central government has specified for the purpose of subsection in bracket 1 quote 8,000 rupees D quote as monthly wages wide SO 1258 in bracket E dated 31st May 2010, full stop. It is true that White Gazette notification published in the Gazette of India dated 3rd January 2020 SO 71 in bracket E has been issued, whereby in exercise of its authority provided under section 4 in bracket 1B, the notification dated 31st May 2010 has been revised and the monthly wages with effect from the date of publication of the notification in the official gazette has been enhanced to rupees 15,000 in bracket 15,000 rupees bracket out, full stop, para. Honorable Supreme Court in case of K. Shiv Raman and others versus P. Satish Kumar and another 2020 in bracket 4 SCC 594 has held that the effect of the notification is not retrospective but prospective, in as much as the amendments enhancing the compensation payable under the 1923 Act confer a benefit upon employees, a corresponding burden is imposed on employers to pay a higher rate of compensation, full stop, para. In case of Kerala State Electricity Board and others versus Valsala K and others 1999 in bracket 8 SCC 254, it has been held that the benefit of an amendment enhancing the rate of compensation does not have retrospective application to accidents that took place prior to coming into force of the amendment, full stop. Admittedly, in the present case, accident took place on 17/6/2019, full stop, over. तो फ्रेंड्स, ये हो गया डिक्टेशन 120 से 123 की स्पीड में, ठीक है। तो अगला डिक्टेशन 1 मिनट बाद शुरू करेंगे, ठीक 5वें मिनट पे। जो इस चैनल पे नए हो प्लीज़ उसे सब्सक्राइब कर दें, शेयर कर दें, लाइक कर दें और अपने दोस्तों से भी लिखवाएं ताकि आपके साथ साथ उनका भी इम्प्रूवमेंट हो सके और सब्सक्राइबर हमारे बढ़ सके, ठीक है। चलिए, ताकि आपको, और बेल बटन ज़रूर दबा दीजिएगा ताकि टाइम टू टाइम आपको डिक्टेशंस मिलती रहें। ओके, चलिए फिर शुरू करने वाले हैं डिक्टेशन। पंद्रह सेकेंड से। क्रिमिनल मैटर, ठीक है। स्टार्ट। The instant petition under section 482 of the Code of Criminal Procedure, 1973 in bracket for short the code bracket out has been preferred to quash the order dated 14/1/2020 passed in criminal revision number 230 of 2019 Alok Naithani and others versus state by the Court of First Additional District and Sessions Judge Rishikesh Dehradun in bracket for short the revision, as well as the order dated 29/2019 passed in criminal case number 337 of 2018 State versus Alok Naithani and others by the Court of Additional Chief Judicial Magistrate Rishikesh in bracket for short the case bracket out full stop para. By the impugned order dated 29/2019, an application for discharge filed by the petitioner on the ground of territorial jurisdiction has been rejected, and this order dated 29/2019 passed in the case has been upheld by the impugned order dated 14/1/2020 passed in the revision full stop para. It appears that an FIR was filed by respondent number 2 against the petitioners on 19/1/2018 under section 498A IPC and 3/4 of Dowry Prohibition Act 1961 full stop para. It is this FIR in which after investigation charge sheet has been submitted, which is basis of the case full stop. At the stage of framing of the charge, an application for discharge was filed by the petitioners on the ground that the alleged incident occurred in Forest Colony, Lansdowne, District Pauri, Garhwal. Therefore, police at Rishikesh District Dehradun could not have investigated and submitted the charge sheet in the matter full stop. After hearing the parties, by the impugned order dated 29/2019 passed in the case, the application was rejected and court directed that there are efficient grounds to frame charge under section 498A IPC and 3/4 of Dowry Prohibition Act 1961 against the petitioners full stop. This order was further challenged by the petitioners in the revision full stop. The revision was dismissed full stop. Aggrieved the instant petition full stop para. Learned counsel for the petitioners would submit that the orders are not lawful. The judgment in the case of Rupali Devi versus State of UP is subject to various aspects full stop. It is argued that in the instant case, the investigating officer did not investigate the matter properly and even the petitioners have not been examined by him. Full stop. Learned counsel relied on the judgment in the case of Naresh Kanwar Chand Khatri versus State of Gujarat and another full stop. Especially reference has been made to paragraph 7 of the judgment, which is as here under :para. It is of some significance that the High Court exercised its jurisdiction even without notice to the petitioner full stop. The investigation has to be carried out on the basis of the allegations made full stop. The first information is required to be examined. Statements of his witnesses were required to be taken. The accused were also required to be interrogated full stop. The undue haste with which the High Court has exercised its jurisdiction in our opinion should not be encouraged full stop para. It may be noted here that issue in the case of Naresh Kanwar Chand Khatri in bracket Supra was with regard to transfer of investigation from one police station to another full stop. In that case, when petition was filed, investigation was transferred merely on the basis of the statement full stop over. चलिए फिर नेक्स्ट डिक्टेशन में मिलते हैं. ओके, थैंक यू.